Honorable the Prime Minister, distinguished dignitaries of the dais, distinguished invitees. You're part of a unique conference, unique in several senses. This is the first time, perhaps, after independence, all of us are assembling at the national level in the national capital to share our insights, experiences, and concerns relating to the district judiciary. This is also the first time that we assembled to remind ourselves that what concerns the district judiciary concerns the entire administration of justice at the national level. This is further unique because this conference will set in motion, institutionalizing the periodic stock-taking of the internet connectedness of administration of justice. This is also unique in the sense that the Supreme Court of India organized this conference inviting the entire legal fraternity to focus on the concerns which confront the entire district judiciary. I must hugely appreciate the ever-energetic Chief Justice of India and his companion justices for conceiving this conference. It is indeed very significant that the Honorable Prime Minister of India is with us today. That the Prime Minister who always intently listens is with us means that he is keen to underscore the importance of this conference. I mean to say that when the Honorable Prime Minister listens, he acts and executes what is just and for common good. The conference subjects have been chosen carefully, and all of them are so connected. And I will be too glad to be any part of any task to be undertaken. Just as the nation is moving into momentous stages of integrated social and economic development in the midst of visible and invisible challenges, global and domestic, and development informed by equity and equal regard, social partnership in new forms of knowledge and wealth creation, courts are called upon to be partners in these national transformation programs. A good governance takes all suffering seriously, and courts are meant to take suffering seriously. The district judiciary takes the bulk and mass of justice demands and causes of we the people of India. It's called upon to be closer to the people in its task of doing justice. Taking suffering seriously and doing justice relevantly are so connected that the underlying tasks and agendas have to be drawn nationally. Administration of justice, if to remain in aid of citizens' pursuit of solace and comfort, ease and enablement, these agendas are important. How do we make and shape our court systems place of solace and comfort instead of being burdensome and uninviting? How do we ensure that the court environments are as good as the environments of leisure as would immensely contribute to the efficiency quotient of doing justice? How do we guarantee to the judges' work and service provisions that will incentivize honest and committed involvement? How do we creatively and innovatively develop emerging technologies as tools of doing justice? In a fundamental sense, how do we ensure that the district judiciary is enabled to bear its burdens with manifold support and assistance that they cease to be burdensome? Debates on these questions are timely. Unless the district judiciary is poised as good and important as the higher judiciary, national commitment to justice will be incomplete. Technology has come as a great boon to take care of doing away with current time-consuming and dispensable physical distances involving exercises. Probably, we need a national district judiciary capacity building commission. I say so because for long, Supreme Court has been involved in addressing the concerns of district judiciary. It is time that it gets institutionalized with the participation of government and the courts. I must also point out that the burgeoning call for rights enforcement and the expansions of rights horizons have ushered in new challenges for courts at all levels. Even if one is critiqued, I wish to say that there cannot be excessive and undue demands which will stress governance and bring fissures. Rhetorics and responsibilities do not go together. The dharma of sharing social costs and social wealth and responsibilities is a misunderstood subject. All of us therefore called upon to be positive contributors and not armchair critics. We need to be explorers and not shipbreakers. It's important that certain tasks are left to be responsibly taken care of by governance institutions, that they continue to be responsible. And even in a common march, task assignment are important. As I gather from comparative information from other countries, we are doing fairly well with the technology use. If what is being done at Supreme Court and High Courts can be done at the district level, the legal fraternity will become harbingers of new dimensions of doing justice. The call of the conference is a different call on the shoulder of the legal fraternity. I therefore deeply appreciate the very important conference. Thank you for your attention.